Hello students. So today we're going to look at student testing and see what the courts have said about student testing. Certainly in an era now when we have so much testing going on and so much tied to that testing, we think of the state test for this when we think of student testing, but we're going to see that this includes other kinds of testing for placement and where the courts come down on this. And basically look, one of the big pictures we'll see is that states testing students in a state testing format is legal. But the other testing that really comes into question, a lot of that stems from the civil rights movement and testing for placement and so forth, and we'll see how that comes about in this short video. This one is going to be rather short compared to some of the others. So one of the things then that we start with here is we know that the state has the authority to set standards for promotion, graduation, and public school programs, and to establish criteria by which students are to be evaluated. And because the state provides a framework for curriculum, and I use that purposefully when I say framework for curriculum, that is in a whole other class, curriculum development, but what we see in the standards is not our curriculum, even though many schools use that as a curriculum. That is the framework, and because the state provides that framework, and the tests are reflective of that framework, everything is legal. And so the state testing is legal. Now, the courts have been reluctant to substitute their judgment in academic matters for that of school officials. And what we'll see is really when the courts are looking at testing, they're wanting to see if a student's rights have been violated more in the sense of an equal protection case as opposed to is it legal to give the test or not. And so that's what we're going to look at and see where the courts are ruling. So the idea of schools and states being able to give student tests is not in question, as long as there's a framework that exists upon which those tests are built. And for the most part, the courts say in this statement here, what they're saying is they're going to defer judgment to the academicians who are in charge of that testing. We do have a few big cases here, though. The first one here, the Board of Curators, University of Missouri versus Horowitz in 1978. Here the courts reiterated that they are particularly ill-equipped to evaluate academic performance, and so on a lot of this they're going to defer to the state education and the teachers and or professors, because a lot of the stuff in the text talks about professors. It does not just talk about K-12 schooling. So long as the school committee acts in good faith, their conduct in formulating and applying the standards, where schools act rationally pursuant to a legitimate academic purpose and a fundamental constitutional right of the student is not denied. And so one of the cases that your book discusses is a case in which somebody brought up and said that the tests were unconstitutional, and they showed that the test reflected the state framework. And so that's what we mean when we say here where schools act rationally pursuant to a legitimate academic purpose. And in this case, teaching the state issued or sponsored framework, however you want to say it, then the school is acting in good faith and there's no constitutional issues involved. And we'll come back to the Horowitz case in a bit, I believe. The Gaspar versus Britain case, notice this made it to the 10th Circuit. This did not get to the Supreme Court. The Supreme Court didn't hear it. But again, this reiterated, actually, I guess this one was before the last one. I think the last one was 78. But the court here said the courts are not equipped to review academic records based upon academic standards within the particular knowledge, skills, and expertise of academicians. And again, they're simply saying we're going to rely on what, as long as all the pieces are in place, then we're going to rely on the judgment of those who are in the field. The court may grant relief as a practical matter only in those cases where the student presents positive evidence of ill will or bad motive. And that's what we're going to see is when the courts really did come down on student testing, it was as a result of ill will or bad motive. And specifically, again, this goes back to the civil rights era. It was to do a lot of ability tracking to disaggregate students once they were in desegregated schools. You know, just to give you that brief timeline, 1954 was Brown. Brown 2 came out in 55, which said all deliberate speed, whatever that meant. By 1968, though, few schools had really done a lot toward integration. And in 1968, the Supreme Court came down with the Green decision and issued the Green factors and said, this is what schools have to do in order to gain what is called unitary status. Unitary status means that you are operating a desegregated school. And it wasn't until 68 that schools really started implementing tactics that would actually desegregate their schools. And so it's no surprise then that we see these cases coming up in the mid to late 70s, because once they get desegregated, legitimately desegregated, then we see things happening inside the schools themselves where the black and white students are going to school. And that's when these cases are really starting to come about, dealing with testing. And so in this case, the courts ruled that as long as there is no ill will or bad motive involved, then the courts are not going to interfere. But the cases that were reviewed show where that ill will was involved. Typically, courts have only entered the picture in times that the students move from grade to grade or for graduation. And here there's a distinction made that's important. The courts have ruled that the graduation ceremony and graduation diploma are not the same thing. Basically, they would say that every student has an equal right to a diploma, finishing school and graduating, but the actual ceremony itself is not one of those rights. And so they do not get involved in that. So why do we do all the testing that we do then? And this comes under educational accountability. And so the courts have ruled that there are legitimate reasons for competency tests. First, here we see students have mastered certain skills prerequisite for a high school diploma, promotion from grade to grade, or placement of students into remedial programs. Any of these reasons for issuing a test are considered to be legitimate reasons. Now, of course, while Oklahoma does not have an official graduation test for the diploma, I would say we have a de facto graduation test in the sense of passing 4 out of 7 EOIs. Of course, that may change, and we'll see depending on what the legislature does with the testing requirement bill. A second legitimate reason for a competency test is for students with deficiencies which have been identified. And third, students are provided the appropriate types of classroom instruction. So those are the reasons, legitimate reasons, that we can use competency tests for. Now, a lot of the book touched on due process and whether or not we have a due process issue involved in student testing. And keep in mind, when we're talking about due process, we're talking about two types of due process: procedural due process and substantive due process. And under substantive due process, we're talking about rights that a person has, a property interest or a liberty interest. And what I'm going to do real quickly is just change and look at this real quick, just to refresh you on what the liberty and property interests are. And both of these refer back to Roth. And in dealing with due process, the first time we mentioned these two terms was talking about teachers and non-renewal of contracts. And property interest is that tangible stuff that you can discuss, like contracts, tenure status, legitimate objective expectation of reemployment, those kinds of things. Those are property rights that are in place for you. For example, if the school doesn't notify you by a certain date, and I know this date changed a couple of years ago, I don't know what it is, whether or not you're going to be renewed for the next year, then you're automatically renewed. That's a property right that you have, so they can't come back after that date and say, oh, by the way, we're not going to renew your contract for the next year. And then we have, I'm skipping through some of this because we've done this. So we'll look at liberty interest here in a second, but just to reiterate, the procedural due process deals with denying rights in a fair and impartial manner, actual legal steps that must be taken, requires notice and opportunity to be heard. Purpose is to prevent state from making a mistake. This is the due process for procedural due process. Substantive due process, and what we're going to see is that the courts really don't get involved in procedural due process when it comes to student testing. It really is in the substantive part where where the courts get involved. And you can see that this makes sense to what we were saying because it talks about the extent and nature of the content of due process, but really it's the second and third one here. Deals with keeping personalities, beliefs, etc. of one in power from demanding, and then his or her will, not the government will, interest on subordinates. And so let's now skip back to our due process here, since we have a better idea of what we're talking about. To have a property interest in a benefit, a person must clearly have more than an abstract need or desire from it. He must have more than unilateral expectation. He must instead have a legitimate claim to entitle it. So the question then that we're asking is, do students have a property interest right in an education? And if so, can that be taken away through a test of some sort? And this, I thought, was the best quote from text regarding this. A person's interest in receiving a public education is beyond a mere unilateral expectation. It is essential to success in today's society. Thus, public education, which culminates in the all-important diploma, may be viewed as an entitlement to every citizen. And a student has to perform to expectation. So, in other words, what we're saying is that a student does have property interest in gaining that diploma, but the courts aren't going to concentrate on this. What they're going to concentrate on is the due process that involves those liberty interests. Academic evaluations of students, in contrast to disciplinary determinations, bear little resemblance to the judicial and administrative fact-finding proceedings to which we have traditionally attached a full hearing requirement. In other words, what the courts are saying here, again, back to Horowitz, is that while disciplinary actions the courts are going to get involved and may get involved in disciplinary actions, but when it comes to the academic input from teachers, professors, and professionals, the courts are really not going to get involved. When they do, it's going to be on the substantive due process piece. So in 1985, the courts ruled again, going back to Horowitz, students do have a substantive due process right to a continued enrollment. This right cannot be taken by any arbitrary reason. However, university faculty have a wide range of discretion in making judgments as to the academic performance of students. And this was in regard, I believe, to a court looking at a student who was basically doing an internship, and the university said the student was not going to be able to fulfill this internship at the level they expected, and so they did not pass the student. And it went to court, and the courts ruled in favor of the university, hence saying faculty have the discretion to make these types of decisions. Students have protection from unjustified discrimination. Here is where we really see the whole idea coming together in the sense of liberty rights and substantive due process, is when the courts again started noticing that as schools began to desegregate and move together, that what they were doing were starting to disaggregate within the schools. And that's what this court case in 1967 dealt with, equal protection to that property right of a fundamental education that we just said everybody has. And what was happening in the late 60s was that schools were testing students to track them and put them in lower classes. And the courts looked at this and said that teachers acting under false assumptions because of low test scores will treat the disadvantaged student in such a way as to make him conform to their low expectations, creating a self-fulfilling prophecy based on false assumptions that black students are intellectually inferior. And this I still believe is true today. And so when I hear teachers say, oh, I wish I could just put all my low math students in the same class, it just makes me cringe, because what's going to happen in that class is exactly what they said 45 years ago would happen if we did this to black students. And that is, teachers will have low expectations of those students because they know that these are all the low math students, and therefore those low math students will actually perform lower because their teachers expect them to perform lower. And so when I hear of tracking, and I see it in schools that I visit around the country, it just goes all over me because of this logic that was stated 45 years ago by this federal judge. But in Hobson versus Hansen, they discussed this idea of tracking students using tests. It was ruled unconstitutional, and the reasons for what we just said: low test scores mean inferior students treated low-scoring students with low expectations, and this created a self-fulfilling prophecy for those students. When they did poorly in these low classes, then that was exactly what was expected of them. The effect of this was a racial disparate placement of students. I should say racially. Tests could not be shown to measure what it's supposed to measure, unbiased and educational necessity. If we're going to use tests to place students in special programs, special ed, or anything like that, the idea is that the test has to be a valid test, and the term validity means that the test measures what it is supposed to measure. Those of you who've been through ed research and advanced ed measurements know that validity and reliability are two key components of every assessment whether it's a survey or whether it's a formal assessment such as tests, they have to be reliable and valid. Reliability means they measure what they're supposed to measure, and valid means that they are consistent, administered over a long period of time, multiple times. The courts ruled that these tests were not valid, and therefore that this was ultimately demeaning to black students, and therefore it was unconstitutional. That's why tests to track students is unconstitutional. So what we end up doing today then is, I believe in some cases that I've seen, we use tests. We use state testing. We put the low students in the low classes. But we've replaced state testing with teacher judgment, which is probably even worse because it's less objective than those state tests are. And so, in my opinion, it'd be interesting to see what a judge would say about this, or a lawyer. I think that we're doing much worse in some instances today than we did back in the late 60s. Again, the case in California in 1972, all this falls under equal protection. Equal protection to what? It's equal protection for access to that public education that we established was a property right that every student had. IQ tests used to evaluate and place children in special ed classes were unconstitutional because they were not validated. The Ninth Circuit Court of Appeals in Denver looked at some similar cases and said that tests were not validated. They were, the state, and I forget which state this was, the state was not using a statutorily mandated test to test students, and the end result was this applied a discriminatory effect analysis. In other words, there was a disproportionate number of black children identified for special ed, and therefore the use of these tests from this Ninth Circuit case, and I wish I had put in what case this was, were held to be unconstitutional. However, no proof of discriminatory intent, thus is not a violation of constitutional rights. So while it was held to be unconstitutional, at the time there was no ill motive or intent of the district in doing this, or the state. Again, I can't remember the case, and therefore there's no violation here. But the way I read this is, once this happens, though, now that they know this is the case, they have to address these concerns. In other words, they cannot continue to use this same method and knowing this stuff, because now that they know it, if they continue to use the same method, then there would be ill motive attached to it. Your book talks about this term intent. What I've been using is ill motive. And the 76 case of Washington versus Davis talked about the need more than an effect test. In other words, what we're talking about here when we say need more than an effect test, the effect analysis here in this case was that there was a disproportionate number of blacks. We realized that. But the court said we need more than that in order to find them in violation of the Constitution. The plaintiff must prove discriminatory intent. And again, so once that case, this last case, this Ninth Circuit case, once they showed that this was what was happening, if they continued that same pattern, then there would be proof of discriminatory intent. Okay? And racially disparate results alone are not enough to invalidate a selection based on test scores. It's that idea that they know what they're doing and they're still doing it. Okay? It's all about that intent. And you can see this case come out in 76. This is when we really see a lot of these cases coming out about testing and finding them invalid because of this discriminatory intent. If that intent exists, then it is invalid. Equal protection, your book talks about academic grouping under equal protection. Achievement grouping is not unconstitutional per se. Okay, now I know I just talked about putting our low algebra students in class together, and I gave you the reasons why I don't like that practice, though I've seen it. It's not unconstitutional per se if, and here's the if the school has operated a unitary system. So in other words, if the school has not been under federal desegregation orders, and I was in a school that was under, that is currently under federal desegregation orders, and this was one of the areas that we looked at. But if a school has not been under federal desegregation orders, meaning that everything is kosher in the school as far as the races, if the school can then show that the ability grouping is not caused by past discrimination, then the students' rights are not violated. And again, I think that this practice in general is a poor practice because I think the old idea of you're only as strong as your strongest link comes into play here. And if a teacher teaches to the top of the class and the top of your class is at best a high, low-performing student, then I think that is, in my mind, that is a liberty interest that those students are being unfairly treated. But they haven't asked me my opinion of this yet, they being the courts, but obviously you know that I'm against academic grouping of students. We mentioned this a while ago as we start to wind this down here. We talked about testing validity. Tests have to be testing what they're meant to be testing. The test is fair if the subjects test parallel the curricular goals. The substantial number of teachers taught the curriculum. And so what we're saying here is that the state tests are valid tests because they are parallel to the state goals. And in theory, we have teachers teaching the state curriculum framework. And I'm going to add curriculum framework there again because I do not see the standards, the C3 standards, as a curriculum. It's a framework which we can build and elaborate to create a curriculum. If the tests are used as a reward, though, the test must be validated for that purpose. And here we can, where this really comes into play is there was a case in the book that talked about using SAT scores to reward students in high school. And SAT scores are not used to judge how much a student learned in school. SAT scores are used to predict how well a student may do in college. And therefore, you cannot reward students for high school performance based on their SAT scores or their ACT scores because those tests are not validated to judge how much a student has learned. The purpose of those tests and what they have been validated for is for future academic performance. And so that's an issue where the test validity and using those types of tests in the wrong way comes into play. Your book mentioned several times the Deborah P. case, 1979. And again, it's no surprise that this is in the 70s and it comes out dealing with racial segregation. The courts ruled in Deborah P. that states could not use tests if they perpetuate the effect of past school desegregation. It is not needed to remedy those effects, and you can see how they overlap with um, the case we just talked about here, or the information we talked about in academic grouping, where we said uh, achievement grouping is not unconstitutional per se if a school has operated under a unitary system. So what Deborah P. says is schools cannot use a test if it perpetuates the effects of past school segregation. In other words, if the tests are used for tracking students or for grouping students, and that school has a history of desegregation or segregation, then they cannot that cannot be a valid use of the test. Basic literacy tests important for eradicating vestiges of past racial discrimination. Document the validity of the test. Provide remedies for students failing tests to overcome their deficiencies. And finally, once all that is in place, then we'll see what will happen. But there are no Supreme Court decisions dealing with this. And so you can see, to kind of summarize the whole issue of testing, students have a property right to a high school education, and that high school education culminates in receiving their diploma. And so if we see any kind of testing that comes in that is going to take away that right, then students are guaranteed certain steps in their due process. And schools have to, and I say schools, really this is directed by the states, but schools have to have good intent or good motive in administering these tests. And the basic idea of these tests is that they are legal as long as they do not discriminate. And that brings in that whole unitary status and desegregation stuff of the 60s and 70s, because that's what they were doing. And it all goes back to that property right. The student has a right to an education. Okay, so hopefully that kind of gives you a broad picture of where the courts come down on student testing. Again, the courts have said that they are not going to really get involved in academic decisions, where they may get involved in disciplinary actions, and pretty much everything up to this point we've talked about has been disciplinary actions, whether it's against a teacher or a student. As far as academic decisions based on testing, they really don't get involved unless it infringes upon that student's ability to that property right of a high school diploma. So I hope that kind of summarizes it for you. I know we kind of went around a little bit in there, but I tried to pull it all together for you, and hopefully that will make sense. So enjoy that, and I will talk to you soon.